Today we are going to talk about the company law. Previously, the law relating to companies in Malaysia was covered by the Companies Act 1965. However, now there are new act which is Companies Act 2016 enforced on the 21st January 2017, replacing the previous act. And the objective for the introductions of this new act is to provide a regulatory framework for starting businesses and subsequently reduce costs of doing business. Furthermore, it will provide a very flexible regime in managing the company. The definitions of the corporations. As we know that the company is a legal entity which is different with the partnership. We have discussed previously what is the meaning of the partnership, what is the element for the formations of the valid partnership, which is it must be a relation between two or more persons carrying on a business in common and for the benefit of profit. The facts that the partnership, whether the partnership has been registered or not, is not render the partnership is invalid. As opposed to the company, in order for the company to become a valid company, it must be registered officially under the law, which is the company must be registered under the CCM. What is it? It is a Companies Commissions of Malaysia. In Malay, we call it as SSM, Suruhanjaya Syarikat Malaysia. Section 3 gives the exclusion. There are some corporate bodies, there are some entity which is not considered as a company, which is any corporate that is incorporated in Malaysia by notice by the minister and published in the Gazette, declared to be a public authority, or any body corporate which is not incorporated under the commercial purposes, meaning that there are some public authority also incorporated under the law of Malaysia by Gazette, but it is not a company. And this not for the commercial purposes. This excludes from the definition of the company. Number 2 is any corporate soul. Number 3 is any society registered under any written law, maybe under the ROS, Registry of Society, or to cooperative society. And number 4 is any trade union registered under any written law as a trade union. As we know that trade union is a body which is not a company. Therefore, the law exempts several entities incorporated not for the commercial purpose as a corporations. The introductions of the new Companies Act 2016, actually there are some features. In summary, we can say that this act introduced a single member or director of the private company. Previously, if we are talking about the formations of the private company, the minimum director, it must be a 2-person. Now, the director, it can be 1 person only. Number 2 is it abolished the requirement for private companies to hold AGM. Number 3, abolish the maximum age for directorship. Previously, the maximum age was 72 years old. And furthermore, the company will no longer be required to state its authorized share capital, and the written shareholder resolution procedures are introduced for the private company. Normally, the procedure, this is the enhancements from the previous act to make us more simple, to make us easier to manage the administrations of the company. Okay. When we are talking about the incorporations of the company, it is important for us to understand the doctrine of separate legal entity. This is a very basic principle